What are the major differences in US versus EU workplace privacy? Imagine working in a place where your personal data is treated like a secret treasure, or one where your rights are clearly spelled out and protected by law. That's what workplace privacy is all about. Today, we're going to look at how the United States and the European Union handle this topic differently. In the European Union, there is a strong, unified law called the General Data Protection Regulation. This law applies across all member states and covers how employers can handle employee data. It sets clear rules that protect employees' rights, like the right to see what data is kept about them, correct mistakes, or even ask for their data to be deleted. Employers must also tell employees why they are collecting data and how it will be used. They need to do regular checks to make sure they are following these rules. If they don't, they can face big fines, sometimes up to 4% of their total worldwide income. In the United States, things are quite different. There is no single law that covers all employee data privacy. Instead, the country relies on a mix of laws that focus on specific types of data or industries. For example, the Health Insurance Portability and Accountability Act protects health information, while the California Consumer Privacy Act covers residents of California. These laws vary a lot from state to state. Some states have strong rules, and others have very few. This means that employee privacy rights are not the same everywhere in the US. The European Union's law also requires employers to do detailed assessments before handling sensitive employee data. Employees are informed about what data is collected and how it will be used. In the US, employers are less often required to give notice or get consent before collecting data. They usually only follow rules that apply to their specific industry or state. Enforcement is another big difference. In the EU, data protection authorities make sure companies follow the rules and can impose large fines if they don't. In the US, enforcement is more scattered, with agencies that have fewer resources and less power to punish companies. This often means less protection for workers. When it comes to handling employee data, EU employers must be very careful. They need to conduct impact assessments and keep employees informed. US employers, on the other hand, have fewer obligations and can process data with less notice or consent, depending on the law. For workers, this means that in the European Union, their privacy rights are stronger and more clearly protected. Employers must follow strict rules to keep employee data safe and private. In the US, the rules are more complicated and less uniform, which can make it harder for employees to know what their rights are or to have those rights enforced. So the main difference is that the European Union offers a consistent, comprehensive approach to workplace privacy, emphasizing employee rights and employer accountability. The United States relies on a patchwork of laws that vary by state and industry, leading to less uniform protections. This means that in the EU, workers generally have stronger privacy rights, while in the US, those rights depend a lot on where you work and what kind of data is involved.